the tree next door, which is really about the neighbor's tree. And it seems like I hear this complaint more frequently. In fact, the question is, what do you do about the tree next door? Um, or what can I do about the neighbor's tree? Or my neighbor just butchered my tree, and or poisoned it or cut it down, you name it. The tree next door seems to be a contentious issue right now, or there's just a lot of anger issues right now. But oftentimes we see these issues with the neighboring trees, and usually it's a threat of safety or some type of elevated risk that typically brings people to the attention of their neighbor's tree. Or, for example, the view of your window may be blocked because of some vegetation like a hedge or something, or dropping dead branches. But all of those things do play into a role as far as what you can do legally as far as remedying the situation. So the first thing I do want to qualify is, before you take any action, make with a neighbor's tree or any other shrubbery, whether it's pruning, removal, make sure that you establish ownership for the rights to work on that vegetation. And that includes the tree care company as well. And we'll talk a little bit more about that. But again, I want to make sure that everyone understands I'm certainly not a lawyer and I don't play one on TV, but you do need to know some legalese and be aware of at least some of the legal ramifications that come along with that. So I'm just going to bring up a few that I've had experience with, especially here recently, and some of the things that really every homeowner, tree owner should know. So what I'm going to talk about is, what can I do? Okay, whose tree is it? That's the first thing. I just remember or mentioned that, and the fact that the boundaries and the boundary laws, we'll talk about that. And what are the rights and responsibilities of a tree owner or tree manager involving tree care? And what do you do about trees that encroach onto others' properties or onto yours? So those are some of the most common questions or concerns that I get, and that's what we're going to be talking about. Well, I'll start with tree ownership. And again, some of these, there's a lot of words on here, and but I want to make sure that I get the exact definition here so that I don't misspeak from a legal standpoint. But until severed from the land, and again, this is also reflective of Indiana law. Now, every state can be different. Well, by and large, there's a lot of similarities in the law books as far as tree ownership and boundary laws. But again, until severed from the land, trees are the property of the owner of the land where the tree trunk is physically located. Now, trees don't always respect boundaries, and nor do they read the plats or property lines. So oftentimes there can be some issues there with sharing ownership, or even actually where the tree actually resides relative to the property line. So the location of its outstretched limbs or its underground roots is immaterial. So it doesn't matter if the limbs come over onto your property, if the trunk, the origin of that tree is on your land or on the neighbor's land, that's who owns it. So when it comes down to it, wherever that trunk sits, that's who owns the tree. Now, in Indiana, we have rights as a landowner that to plant or remove any type of vegetation on your land, however you please, even if it affects the neighbor's view or regardless of the situation. In Indiana, a landowner can do whatever they want to do on their property as long as it doesn't jeopardize public safety or health. Now, in Indiana, the law requires that you use what we call reasonable use to maintain their property. And again, it should not interfere with the neighbor's use and enjoyment of their property either. So the law of nuisance applies to, in Indiana, applies to noise. It applies to artificial light. So example, if you put a spotlight up and you have light trespass onto the neighbor's house, odors, water, trash, animals, whatever, that if that causes harm to the neighbor or their inability to enjoy or use their property, then you got an issue. And there's no reason that trees should be any different there. So also there comes with that tree ownership some liability that goes along with it. And there's some key terms in here that I want to make sure we highlight. And primarily it's this one, reasonable care. So in Indiana, we have precedents that says that property owners have a duty to inspect and maintain their trees, simply stated. Um, Indiana law, by definition, imposes that the landowner has the obligation to use reasonable care. So, reasonable is a very important term to define um, in the law, in the fact that what is reasonable and prudent for that typical person. Or in other words, what would a prudent person have been aware of or notice relative to danger? And could they or should they have taken steps that would have prevented that foreseeable harm? Just like you see this dead tree landing on this poor Pontiac. So again, who owns that tree, and is it reasonable for that tree owner, that property owner, to have noticed that and should have mitigated that damage? So again, it comes down to basically due diligence or a duty of care as a tree owner to understand what reasonable care is. And that can vary depending upon the site, the resources available to you. For example, standard of care can be a lot higher for, say, a university campus as opposed to a resident. Obviously, the campus has resources with arborists and that should and could identify issues in advance of some type of unforeseeable or catastrophic event. Whereas the average homeowner may or may not see that, or they may not even be able to get out in their yard and do an inspection. So you have to make sure that you understand what the standard of care and what the duty of care is for that particular location. Now with boundary line trees, it gets a little tricky. Trees where the trunk straddles the boundary line between the two parcels result in what they call joint ownership. And one of the best ways to first figure out what or who owns that tree is I recommend looking at your county GIS maps. And I think pretty much every county has GIS layers. I know this came from Tippecanoe County. And you can pretty much filter out whatever you want as far as drainage, stormwater, rights of way, things like that. But this is a good one that shows obviously there's a lot of trees that this one in particular, that guy just straddles, that sycamore straddles right in the middle of those two properties. And you can see that there's several here where you got encroachment and you have some overhanging limbs and so forth on everybody's property. So again, you got to get along with your neighbors, but also you got to be mindful and diligent about the care of the tree, and how it would impact, again, the neighbor's enjoyment of their property and also safety. So, for example, if this tree would fall, to this area, again, within that target zone, then that is a condition of concern that needs to be inspected and maintained on a regular basis. But again, you got to make sure that you determine ownership first. And if something needs to be done with the tree next door, first of all, it's recommended that you do something as far as communication with the neighbor. So this was actually a graphic that I borrowed from Russell Tree Experts. And you can see that obviously this is maybe not always as perfect as this one, but you can see that obviously that tree straddles the property line. So who owns it? Well, again, this is where we have what we call a jointly owned tree, and each person has a right to that tree as far as the functional benefits that tree would provide. Now, neither owner by law may remove or injure that tree without the other's consent. So it's kind of like you both bought something and you both share ownership of it and rights to it. So even any minor trimming shouldn't occur until some type of communication has been established between the owners to resolve the dispute, hopefully in a favorable manner. Now, if you're not sure, and again, boundary lines are often in dispute. Oftentimes, even title companies may be inaccurate in some of their description of property lines. So, the best thing to do, and this has happened to me frequently when I've consulted with boundary issues with trees, and the first thing I ask them is, "Who owns the tree?" And of course, the typical answer that you have from that person that you're working with, "Well, it's mine, or I wouldn't have called you." Well, let's not be too certain about that, because if it's close to the property line or what is perceived as the boundary line, then my recommendation is to get a survey. If you're in doubt at all and it is a contentious issue or could develop into a litigious issue, then certainly it's worth the funding to get some type of survey that officially recognizes ownership of that tree. So that's the first and foremost step there, is making sure that you establish ownership so that you know what your rights are regarding that tree. So what's acceptable practice? Obviously, you can see with this cool little graphic. So if you have what we call tenants in common of boundary line trees, you have to respect that ownership of that tree completely, especially where the tree is not directly on the property line, but does have some different implications there. So you have the right to prune or trim on your side of the tree. So the affected neighbor, for example, if this is your property, you have, and the tree falls on the neighbor's property, you have the rights to your boundary line. Now, that has been somewhat contentious in certain situations that I've dealt with. You do have the right to prune or do any type of maintenance to it on your side of the property, but it cannot injure or harm the tree to the point that it would cause decline or dieback or any type of health implications. So you can do some things, but you can't get radical, so to speak, with those trees. So if you have overhanging limbs or limbs are hitting you in the head when you're mowing or dropping fruit or something like that, then you can have that work done. Now, as I mentioned earlier, the only thing that you are precluded from is the fact that you cannot go onto their property without written consent to do any type of maintenance work. And that also goes for any type of tree care company that you may employ to have that work done. So as far as the rights of the affected neighbor, again, as the law mentions, a neighbor really has no right to remove or destroy another person's tree, even if it sheds onto the land or blocks the view. So you do have rights to trim and remove anything on this side of the fence, as long as you do not destroy or damage or imperil the health of that tree. So those are some key things to keep in mind, and also that you don't trespass onto their property, again, without their written consent. All right, so what to do with questionable trees? So this is kind of the summary of what you really need to consider. First, make sure you confirm communications with the neighbor's tree. Not just a talk with them, but get something in writing, either some type of MOU, or I know it sounds very callous and cold and perhaps overly formal, but I have actually been in court where this situation has arisen, and usually it's a communication issues or interpretation of what their discussion was, and it becomes he said, she said. Also, make sure you confirm those property lines, easements, and rights of ways. I even recommend that if anybody's purchasing a property or purchasing a home, is confirm those easements and rights of ways in advance. And I really think that should be part of the full disclosure when you're purchasing a house. Because I have seen situations where There's a huge utility easement that allows utility company to really come in and affect some changes with the vegetation on that property. And the property owner said, look, if I'd have known that easement was there before I bought the house, I would not have purchased the home. So make sure you confirm those, and that gives you an idea of what you can and cannot do on your property and the rights of ways or easements that are adjacent to your property. And then again, make sure you confirm all those actions with written agreements or MOUs, as I mentioned. If you're in doubt, consult an attorney. I mean, oftentimes you may be in the right and speaking in terms of what is correct legally, but it's always good to confirm that with an attorney to make sure that you are exactly where you should be in those discussions. And then, of course, don't act uninformed with regards to neighboring property. Don't assume that you have the right to do anything, especially if the tree is located on their property entirely. Now, with joint ownerships, you do have some certain rights there. But if it's solely owned by the neighbor, regardless if it's a hedge or a shrub or vines or ground cover, whatever it is, there has to be some express written consent there for actions to be taken. So it can get messy, and it certainly does. The whole point is, and attorneys have told me this that I've worked with in the past, is just be a good neighbor and communicate, and some transparency there on exactly what you want to do, and also what is acceptable to them, and hopefully you can come up with a reasonable solution to any neighboring tree properties.